We're going to start with 157 and David Hall. We're going to try and take a vote within the next 10 or 15 minutes, and I just want David to go through the changes he's made from our hearing yesterday, and he will explain one other thing that's in there that I asked him about, that he put in dealing with injunctions that may help a little bit. So why don't we go through pull it up on the screen, David, and let's go through the changes. Good morning, David.
Good morning to all of you. Good sunny morning. It's lovely out, and I'm happy to be virtually with you. While I pull this up, today is today is my 2 weeks out from my second vaccine shot, and I feel like a new person.
All right.
Very exciting.
No, I don't think it means I can do anything any differently, but oh well.
Well, but you feel different. I feel different. I feel much more courageous.
Yes, I do too. I could go to the grocery store with impunity.
I feel like I need a booster.
You've been saying that for a
while. Good morning, David Hall, Legislative Council. This is a committee strike all amendment to H-157, which I circulated to the committee yesterday. Gosh,
yeah,
I have no idea what time it was at this point, but
for those watching, it's now on our website, I hope. Is that right, Nathan? Yes.
It will be when my Outlook issue is resolved.
Okay, great.
Well, if you're following along at home, hopefully you can see the screen. So the changes that I have put in this document reflect your discussions yesterday, and they are in highlights. I have about 5 or 6 of them. And the first one is the double change in the amounts, and is to reduce the house position from 3,500 to 2,500. And that's in both instances. So remember that in subsection A here, this is the dollar amount that triggers the registration. The other number, the other 2,500, relates to the requirement for a written contract for work. The exemptions in 5502, we're talking about exceptions to the rule that you have to register when you perform a certain threshold level of residential construction, right? And you'll remember from the discussion that we have an exemption for individuals who are professionally licensed and regulated by DPS. And the expansion, the addition of the language here is just specify that we are talking about licensed, registered, or certified. It is true that in the underlying statute right now in Title III, that license is a term that is defined, and it is defined to include these other things. But because we're in a separate chapter of the law, and because we want to be very clear about the scope of this exemption, I think it's good to add these words here as the OPR recommended.
David, this is a really small thing, but I was just looking and wondering why it says a professional engineer. Is that a term?
It is.
Okay.
It's a PE, and then among them there are different kinds, but you get licensed as such. So
okay, I was like, as opposed to what? But okay.
An unprofessional engineer.
As opposed to Oliver with a shovel.
As opposed to the chicken house I built.
Yeah, exactly.
So at the top of page 4, the piece that we're trying to capture here is the situation where, you know, the business itself still would have to register because it's checking the box for residential construction. But we want to say that if it's checking that box exclusively through the use of employees who as individuals would be exempt, then the business should also be exempt. Now, what this does mean is that if you have 5 licensed electricians and then, you know, 3 helpers and 1 general construction person who does maybe rough end framing before the electrical work, they're still going to have to be registered. The business itself. Remember that an employee acting within the scope of the employment is exempt already. Any questions on this piece?
Sorry, I thought we were exempting the business, but they're still having to be registered. So they have to, they all have to be, okay, it's a confusing, it's a lot of things in there. Okay, I guess I'm fine. Yeah, keep going. I'm sorry.
I don't mind waiting if you.
Yeah, well, I mean, a business where everybody is licensed, one assumes is exempt. And then, but a business where some are licensed and some aren't is sort of a hybrid, and it does need to be registered. Is that right?
That's a good way to put it. Yes, a hybrid would be required to register.
Yeah, I just don't want to think about it as a hybrid.
Does that complicate things in any way with like apprentices or VTC students?
Apprentices are incorporated, aren't they, under sort of the trajectory of license?
I mean, they, unless they actually have attained their license, then they would not be exempt as individuals, nor would the business.
Well,
So,
as
I
an
mean,
example, you also, people who are not licensed and who are not performing any work that really relates to construction. For example, let's say you have a firm of professional engineers. You have 10 licensed engineers in that firm, and you have 1 administrative assistant who answers the phone. That firm would then, according to this, need to also be licensed in addition to all the engineers, even though that administrative assistant actually performs no construction or repair. Is that am I correct, David?
We specifically wanted to get rid of. That was the exception we wanted to get rid of.
Right.
We didn't want to talk about bookkeepers or owners who weren't actively involved, or the example was given of the mother who runs the office. Didn't we not take care of that, David, by this language?
that's why I chose the words performs residential construction through employees who are exempt.
Got it.
So would then that administrative assistant be exempt from forcing that business to register?
Right. So the administrative assistant in no case as an individual is required to register. And then the business under this language, I mean, the intent, and I hope the language says that it would not, because that person is not performing residential construction. That person is performing office work. Right.
Okay.
The business is performing the defined term, which is broad, but that's what the term is, exclusively through employees. Or, I mean, you can add more words, and it's the construction of writing this is hard because otherwise you have to start saying things like a business that performs residential construction and the work that qualifies or meets the definition of residential construction is performed only by employees who are, I mean, you can do that. You can add more words if you feel like this is not clear enough. I'm certainly not, I don't want to sacrifice clarity for brevity.
So I think it's good enough. I think the intent is pretty well stated here. That's the goal we were trying to achieve, Senator Brock. The House or someone in the previous version said that basically that as long as you had one person who was working as I think it said one person who was a registered contractor, you could have 10 helpers and still not have to register. So we've moved the needle to the other side of the continuum. I don't know if I explained that very well, David, but I think that's what we did.
I hope so too. I think that's the intent. I mean, it really does in the end come largely back to, I think, a good point that Senator Rahm raised yesterday about what terminology we're using and the extreme breadth of it. But again, that is intentional, and that's based on other statutes we have that govern, for instance, the rights of contractors and subcontractors to get paid. To have a single term, residential construction, that captures so many things. You can't pick one verb, that does all of this. It would be 20 verbs. And so our shorthand in this chapter has been perform residential construction, which means to paint, to install electrical work, to sheetrock a wall, to dig it, a foundation. I mean, it's a lot of stuff. So I hope that this captures it. I'm sure you'll hear otherwise if not.
So I will say, we spent a lot of time talking about this yesterday, and I did send this new language to Matt Coda and Lauren Hibbert, and I did hear back from Lauren that she likes it. I didn't hear any objection from Matt Coda. So I think we made some progress anyhow. Let's keep moving on.
Sure.
Sorry, may I just ask, Nathan, is it posted yet, Nathan? Because my email version is not showing any of the highlights.
It's posted to the latest version that I got last night.
So it's posted for today.
Yes.
Great, you're wonderful.
Unfortunately, for some technological deficiency, highlights will only show if you open the document in the Word application.
Exactly.
So if people are at home trying to see highlights and they're not, it's because maybe you're just looking at it in a different format.
Yep, and from an iPad challenge.
So in 6 here, as requested yesterday, the time frame for performing work in an emergency and then needing to register within a reasonable time, that will be specified by rule.
Yeah.
That's the addition there. I don't think we changed anything in that piece. So this in 5505B requires that the director of OPR, after consultation with advisors, shall adopt rules to implement the chapter. These, I don't think I had changes. $2,500 for the contract change. I changed terminology here to try to reflect your conversation yesterday.
Yes, documented instead of reported. Recorded, right?
I added, as you suggested on 9, the addition of or 1/2 of the price of materials. The cost of labor issue, I mean, that's really the first time in this chapter that we would use the term cost of labor. And I think the chair and Senator Rahm both made good points yesterday about, in most cases, the contract price includes labor and materials. And then it was confusing about what 1/2 we were talking about. So I hope this clarifies the intent of I-1.
Yeah, it makes it much better for me. I could never understand how the contract price could be less than the price of materials. So now I understand it better.
All right. So this is the part in 5510A that the chair referenced, and this is mostly just an oversight on the House side on my part in the thrill of battle. You'll remember that as a result of interrogations on the House floor, there were 2 changes made. One being the previous subsection we just saw about the down payment, the other one being here, and this is on the enforcement side. And so right now, under law, whenever OPR faces an issue and is contemplating an enforcement action, it has a range of tools to respond. Remember that there are different things going on in the underlying OPR framework. There is the concept of unauthorized practice, and then there is also the concept of unprofessional conduct. And they are different, and they have a sort of a different enforcement framework in 3 VSA section 127. And right now, for any given profession, enforcement options for unauthorized practice include civil penalties, injunctions, and also the possibility of criminal imprisonment and fines. And the concern voiced on the House floor was that, contractors not end up in jail or have a criminal fine on their record because they failed to register with OPR, which is a possibility, because unauthorized practice means you were required to be licensed or certified or registered and you were not. So the language was written in 5510A to just say civil penalty. And that way they could not pursue the criminal provisions specified in section 127. The problem with that is there's really two other mechanisms, one being the civil and one being the possibility of an injunction. And that gives the court obviously the authority to say, stop doing what you're doing. That's injunctive relief. So it's not a monetary penalty, which is a civil penalty. It's an actual court order that says you can no longer do this until we resolve this issue. So my fear was, without mentioning the possibility of injunction, which is present in the current law, a court or other people might read that to mean that the legislature was stripping the possibility of an injunction. And I don't think that's what anybody meant. It certainly wasn't expressed as a concern or an intent on the House side. So I put it here in line 9 to flag that for your attention and see if you want to preserve the court's ability to issue an injunction in these circumstances or leave it as is.
I like the fact that you caught this, but I do, I don't know if Lauren's with us or have they ever used injunctive powers? This section here is just applicable to residential contractors, right?
This piece, yes, absolutely.
Okay.
Yes, you are not changing the underlying statute. You're just
So
referencing.
in their other professions, have they ever used injunctive powers? And I mean, I guess I'm wondering, does this mean like if you get a repeated violator, do you go to court and get the court to order that that person shall not enter into any future contracts?
Until this is fixed, or
Well, however courts have broad authority how to fashion it, but so that would be the kind of injunction. I'm just wondering, is this language going to be, I like it, and I think it's another tool in the toolbox for OPR, but I'm wondering if they ever really use it in other contexts, and whether this also in any way, does this apply to the AG, and does the AG get any authority under this, or if we don't put it in, are they reduced? I don't think they would be reduced in their injunctive powers under consumer fraud or their powers on consumer protection.
So to the question of whether they've used it, I have no idea. What discussion I did here suggested that they don't actually use the criminal penalty hardly ever. And so the consternation on the floor was, well, that's even worse. You have the power, but you don't use it. why would you hold the possibility of criminal enforcement over somebody's head when we don't go that route? I don't know. I think I don't know enough about the real world side of that. What I know is there's a framework that governs
Right.
49 professions, and that this is creating a deviation from the standard, which says you no longer have the power to use the other tools in your toolbox. You can only use the civil penalty tool. So in that respect, you're charting a different course for this profession than you are for others. I don't know if that matters. Maybe that's appropriate, but I really was just here
Well,
on
I
the.
think it's a useful tool. I don't know whether they've used it in the past, and to the extent they have a problem person out there and they can't for some reason get the attention or the resources that the AG is insufficient. This is in addition to a civil penalty. They could potentially go to court. I would assume they'd only do it in really egregious cases, and
Well,
then the person would be subject to,
And
if it's not an injunction and they violated the injunction, then they would be subject to the mercy of the courts. So,
And Mr. Chair, we have an OPR bill every year.
Right.
If it becomes a problem, we can address it in the out years.
okay, let's go on. I don't know if Lauren is listening. She could maybe write us a quick brief. Otherwise, we'll just go on without her. I hope she's listening.
May I ask a question, please?
Absolutely.
I'd like to go back to the issue of the down payment
Yep.
and the phrase using the cost of labor.
Okay.
Does that mean the cost? Does that mean the price of labor or the cost of labor?
You mean what's charged, or what the profit margin?
The basis for which the down payment being the way it reads now is 1/2 the cost of labor or the price of materials.
Right.
I understand what the price of labor is, but the
Right.
cost of labor is different from the price of labor. And I'm wondering if the intent was really to do price of labor that would be billed to the customer as opposed to the cost of labor, which may be the labor rate paid by the contractor. Something
So
which
I think clearly the intent is the price to the customer. If we
right.
need
And I
to
would,
make that
that's why I
clearer,
would ask that be revised to read price of labor rather than cost of labor.
So, it's interesting. I read this as the price of labor is like $50 an hour. The cost of labor is the total project estimated time. That to me is the difference. And maybe I'm wrong, but so to me, it's
David,
the
David, do you
cost.
have any suggestions? David, do you have any suggestions?
I guess we could say the way that it refers above to the prices in the contract. I hope you're seeing this on your screen. I mean, we say price for work and materials. I put cost of labor, not intending any sort of economic definition of it, but rather just using that because price of work sounds funny to me. But if that's clearer to you, we could say price of work specified in the contract or provided in the contract. I don't know.
Well, you can use either so long as it's specified in the contract so that there's just some clarity, because
Sure.
as I read cost of labor, it told me this is what the labor actually cost to the contractor, which would mean that the labor rate that was paid rather than the labor rate that was charged could conceivably be what we were talking about.
I read it the other way, but I have no problem clarifying it to make sure. I think that my intent would be, they talk about, time and materials and everything like that. I think, the two major factors are how much you're charging for labor and how much you're charging for materials.
You could
So
say
it's what's charged to the customer is not what the general contractor pays the sub.
I would vote for cost just because I think that's cumulative in its understanding. The price of labor, the price of materials could be, $10 a foot. Well, that,
Now, let's forget about materials. We got materials covered. Let's just talk about the other half of the job. Okay. How do you want to define it? Are we all in agreement that we want it to be what the customer pays
Yes.
for that labor? Okay.
Yeah.
Of course.
Okay, so then we just have to find out how to say that.
Why don't we ask a contractor?
Because we don't have time. We have 2 minutes.
I'm just joking. I was sort of hoping we had one in the room, but I guess we don't.
No, cost of labor to the customer, cost of labor to the purchaser.
Okay.
The word effect would clarify.
David, did you base this off a state that's had this kind of law for a long time?
At this point, that's lost to history, Senator. I don't know.
I don't know.
So I mean, literally, we keep saying time and materials basis. So the corresponding terminology would be price of time, which doesn't even make sense. So do you want to say price of work, or 1/2 the price of materials, whichever is greater?
How about the
I'm-
cost
No,
of
I'm
labor?
fine with what Senator Brock said. I think that cost of labor to the customer, you know, that if that makes it clearer that it's to the customer, I think cost of labor is generally a parlance that is used.
Yeah.
People know what it means, but this clarifies it. Is everybody
Okay.
okay with that? Because
Yeah.
I want to move on. Okay, great. Thank you.
All right. And let's see, we have implementation should be the same. We wanted to add that OPR would adopt and publish model contract provisions available to contractors and consumers. I did reference that it's OPR special funds. And Senator Clarkson's point yesterday, the potential design and implementation of a one-stop portal for contractors and consumers. And that's all that I have from yesterday's changes.
Okay.
Thank
Okay.
you.
Thank you. Okay, so I think we're ready to move forward. We can have some discussion on the bill if we want, but maybe Senator Clarkson, you'd like to make a motion and then we can open it up for
I
discussion.
would make a motion that we adopt what draft number is this going to be? That we amend H157 with draft.
Let's make it 2.1 to reflect the changes we've made today.
Okay, with that we amend H157 with draft 2.1.
Okay, this is just on the amendment. Can I see a show of hands? All those in favor of the amendment? Okay, Senator Ballant, oh, you can't vote unless you're visual, right? Okay, so that would be 401. Okay, now Senator Clarkson, would you like to move the bill as amended?
I would move that we adopt H157 as amended.
Okay,
Yes.
any discussion?
Well, Lauren Hibbert just wrote that she supports injunctions in an email to all of us, that
Okay.
she's not in other egregious situations with other professions.
Okay, so we have a
That helps.
motion.
That
We have a
came
motion to approve H157
as
as
amended.
amended in draft 2.1. Is there any discussion? Senator Brock.
I sent a note to Senator Rocket earlier this morning, just kind of outlining where I stand on the bill. And I mentioned that I was somewhat on the fence, but I have some real concerns about the bill. And the nagging concern that I have is, are we just creating another, as I termed, administrative monster with little likelihood of solving the problem for which it's intended? The thing that I'm missing here, and I know that consumer fraud in the home repair business is a real problem. And my concern is whether or not this solves it. The thing that is pushing me more negatively as I look at this is it doesn't get any money back for the consumer who's defrauded. The position of the consumer in terms of recovery is largely unchanged. Their recovery is going to simply still be to go to small claims court or to another adjudication, to another court in order to sue and get their money back. I don't see this helping them. I understand that there are mechanisms for people to find out if this is a registered contractor. It doesn't tell them whether or not this is a good contractor. You may learn through additional certifications at additional cost that this will help. But one of my biggest suspicions is that a lot of the people who would benefit from this, the people who don't typically do due diligence, the seniors, for example, who really don't know whether or not they will actually use this portal and whether it will be of any value to them is a real question in my mind. And my suspicion is that the usage will not be as high as we might want or think. The other issue is regarding the predatory contract. I see this as with many things that government does, is that the honest people will sign up and take advantage of it and pay the fees and get the insurance and pay the taxes and so on. And the people who are the fly-by-night contractors who victimize consumers won't. And I'm not sure that the tools here are sufficient to make enough of a real difference to warrant the cost, expense, aggravation, and so on. I'm concerned about the effect of this on smaller contractors. The notion of the person who, does the small home improvement jobs that don't rise to the level of $2,500 or $3,500, but may do one such job a year, and therefore that ensnares them. Yeah, this is the part-time person that ensnares them in this registration process, which is not necessarily cheap. Lots of folks, even small contractors, operate with an LLC for protection and so on. And in that case, it gets them $500 for insurance, $250 for registration, the written contract requirements, et cetera. And for that small home-based handyman service, this could be a problem, could be a burden. And so my question that is in the back of my mind as I look at this is the cost, the time, the bureaucracy, and everything really, is it worth it? And do the people who are potentially victimized really get anything out of it? I got very little comfort from the Attorney General's testimony that they will intervene in any way to deal with problems surfaced through OPR's investigations. And the notion that, well, this is something the state's attorneys are going to do. My experience, the state's attorneys are busy as it is, and things that are considered crimes get their attention. And this, since there don't really seem to be criminal penalties anyway, won't. So I thought of, well, could we get more data? For example, having a short sunset to look back at what we've accomplished and whether or not it's working. But once you start this process and you get everybody involved in getting licensing and insurance and all those things, and then begin the registry, it's difficult to put the toothpaste back in the tube. What we would do typically is then say, well, can we fix it? And then continue a repair process over multiple sunset sections. So on balance, I'm just very uncomfortable that we are really going to accomplish anything other than creating a monster.
Okay, I would like to briefly respond to that.
Yeah.
First of all, I think, they're colorable points, well articulated. However, I think what you're missing, quite frankly, is the preventative nature of this bill. It's true that there's not necessarily people are going to get their money back, though I think in the process, by having an investigator and the OPR involved, people may come together better. Contractor and customer may come together better, and there may be some resolution in that process. But having this process there, I think, is going to reduce the number of these conflicts that are out there and potentially abuse it. I mean, we could have just put a lot more money into the AG and tell them they've got to make these a priority and get the money back for these people. But a lot of these people are judgment proof anyhow. So, that's sort of part of the problem. But, you want to sort of get these people sort of out of their scamming if you can. So I think that's, I'm not necessarily disagreeing with everything you're saying, but I think you're missing the main focus of this bill, which is the preventative nature. Well, maybe you're not missing it. You don't agree with it. I think that having this structure in place will see a reduction in the amount of these cases and the amount of complaints. And I think that's in part what OPR is doing in a lot of their regulations or certifications. Senator Clarkson.
Yes, thank you. I would say, I would go back to the testimony that it's a Wild West out there, that we're one of the few states that don't shine any light on this profession. And that I would encourage us not to let the good get in the way of the perfect. We can always work on making this a better system. But I think that this enables us to, it creates a framework and it anchors us in OPR. It allows us to do a huge amount of education. Randy, we can reach out to our senior centers now and say, look, if you're even thinking about this, you can have a relative check out who are the good actors who are registered on the OPR. This gives us an opportunity for education. This is, to me, it really helps us shine a light on this issue. And with passing this bill, and we can identify the number of complaints, that this is an area of concern for all consumers. And for me, the biggest issue here is homes are our biggest asset for most Vermonters. Their home is their biggest asset. And this is a step towards protecting them more fully. And I really think that we need to take this first step. I'm hoping that it really does a lot of what we're hoping in terms of prevention, and it enables us to do a huge amount in terms of education.
Thank you. Senator Ballant, we can hold open this vote till the end of the hearing if you're going to appear at some point. Otherwise, we'll.
Yes.
Okay.
Mr. Chair, can you hear me?
Yes. Okay.
Yes, I would appreciate that because this bill is very important to me and I want to cast my vote favorably. If we could wait to vote for 15 more minutes, I think I'll be able to get online at that point. I would like to at that.
Okay. You can speak now if you want. We're going to vote now, but we'll hold the vote open for you to arrive. Okay?
Okay. So what I want to say is, having been the person on this committee who's been the longest serving member of this committee, we have been hearing complaints from our constituents for years on this matter. And I have, as I think about the people in my own neighborhood back in Brattleboro who have been taken advantage of by people who should not be in the contracting business. And yes, this will not get us everything that we want in terms of, holding people accountable for their bad actions towards consumers. But this is long past time that we are looking out for people when they are just simply trying to do repairs to their homes, modifications to their homes. And as Senator Clarkson said, for many of our constituents, that is the biggest asset that they have. And when I walk around my neighborhood, I want to be able to say to my constituents that we heard you and we're doing something. Thank you.
What are you doing?
Senator Rom, do you have anything to say before we vote? I'm sorry to ask you.
No, I mean,
But I did.
I just, while I really honor Senator Brock's concerns, it doesn't seem like a compelling reason to do nothing. I think our choices are between, taking the first step towards something that we know will be a viable solution in the future that many other states have. And, it comes at a time when contractors are actually scarce and hard to find. And I think this helps create a place where people can find a contractor that's trustworthy, because they're so worried about just word of mouth or finding someone by Googling. So I think it's a service to a lot of different parties. And I think inaction, when we know so many other states have acted to try and continue to advance a solution, is just the first step. I mean, we're just, I think, really behind in having such an informal market in the state. And I don't think that served us well. And I believe that this small action is better than inaction at this point. It's something from when I was on the housing committee in the House, we've been talking about for a long time. And I just have so many people say this is such a good idea. And we heard it from other contractors and other professionals in the housing industry as well. So I choose to listen to them.
Thank you. So Senator Brock, I just have one question. Is there
Yes.
anything that we could add to the reporting back that would make you feel a little bit more comfortable and get your vote? Like I'm talking about, like, studying or recommendations, how we can specifically impact compensation to victims. Because I hear you there. I mean, I'm not sure that I think it's more prevention, and I agree with Senator Clarkson. I don't want to sacrifice the good seeking the perfect, but I would like to see these people have. I don't know if other states have, for instance, injury funds or compensation funds. I doubt they do, but I don't know. So I just asked that question before we vote.
Well, as I said, the notion of an early sunset was one of the things that I had in mind with the collection of data. But at the same time, I don't think that would solve the larger problem that I see, because at that point, the money's been sent, the work has been done, the construction of the list has been created, the costs have been incurred. Senator Ram raised the issue, which is a valid one, of how hard it is to find contractors to do work at all. And for smaller contractors, I would expect it will be even harder if this bill is passed, because of the burdens placed on the relatively small contractor who may be entirely honest, but who then is faced with a cost and an aggravation burden associated with this registration process. I just have real concerns as to whether or not this is going to do what's intended, and I don't see it being sufficiently beneficial to help consumers in the real world. The real help to consumers comes from resolving their problem and getting their money back, and this doesn't do that.
Yeah, we have a phrase in the law that I don't know exactly what it is, but the intent is it's far better to prevent the problem from even surfacing,
Sure.
rather than trying to resolve it amicably after or fairly after the problem has occurred. Okay, so let's move on to a vote. Let's take a roll call on this. Senator Ram, do you just want to read the names, please?
Sure, yeah. Are we end of discussion? Okay. And this is the amendment.
This is
This
the
is the final,
bill as amended.
Okay, we just did the straw poll of the amendment, so this is passing the bill. Okay.
this is the bill as amended.
Yeah.
Right. With draft 2.1.
We didn't do
2.1.
a straw poll. We did a vote on the amendment.
we
So
did
that's
a vote.
passed already. Okay.
Okay.
Yeah. and the
By
By
vote-
the way, let me just throw one other thing out, which was another one of my nagging concerns.
Okay.
And that is kind of the growth and outreach of government in areas such as this. And as I look at OPR, I'm reminded, I don't know if you've ever read the book Parkinson's Law.
I haven't read it, but I know the term.
Parkinson's Law is that work expands to fill the time allotted for its completion. And it relates to the inexorable growth of bureaucracy, both in corporations and in government. And once a number of the comments made by those of you on the committee today have led me to increasing concerns. I've heard repeatedly, this is the first step. And what that language means to me is the nose is through the door and the rest of the body will follow in terms of more additional intrusive regulation and oversight that will come. And the bottom line to me is helping people who are victimized by bad contractors and dishonest people. That's a high priority for me. my point in all of this is I think that's a good thing to do. I just don't think this bill does it.
Okay.
So we had, let me just be clear, we had a 5-0-0 vote on the amendment.
Right.
Correct.
No,
Yes.
401.
Was it 401, Randy?
Yeah,
Oh,
for-
Becca wasn't here. Becca was.
Unless you want to keep it open for Becca. Becca was missing.
We don't have to keep the amendment
Okay.
open, Rebecca.
401 on the amendment. So now this is for
Yeah, the amendment's
Bill.
fine with,
as amended by 2.1.
Right.
Yep.
Senator Ballant.
Can't vote right now.
I will vote yes, and then I will appear.
Okay.
Okay.
Senator Clark. Senator Brock.
Senator
no.
Senator Clarkson.
Yes.
Myself, Senator Rom. Yes. Senator Sorokin.
Yes.
So
Okay.
we're holding it open.
Thank you very much, Senator Clarkson. Would you be so kind as to report the bill, given that you've referenced your speech several times?
Given the experience I had on the Senate floor with this bill 2 years ago, even
Well, I'll make a special appeal to Randy to go soft on you on this
he
one.
doesn't need to go soft on me. I'm happy to, I am honored to continue this work.
Okay. Okay, so we'll get that over to, this bill has to go to 2 money committees still, so we'll probably see it next week on the floor. All right, let's move on to, thank you very much, everybody. We'll move on to S79. Let's see. I think I'm going to start with Josh, Commissioner Hannaford, excuse me. We want to focus on the changes in this bill that the House made to our version. I know that's probably going to be mostly the additions of the home ownership, but let's start off with any changes. It could be Sean as well. I mean, whoever's most familiar with those changes. David, I think, has highlighted a little bit of those to us already, but we just want to go through the changes that the House made. So either one of you can start up.
I mean, I'll just speak to the biggest one, obviously, is adding the purchase rehab component to the bill. This was, something that has not been included in the past, but we've heard a lot of support for it and think it's a unique new approach to a long standing need out there. And I think I've heard a lot of reference to the down payment assistance program, that this acts like that. And I think that's a little not really true. I think this acts closer to what's referred to as the manufactured home replacement program, where it acts as this silent second deferred 0% loan until sale or transfer, and then it revolves. The down payment assistance program is a straight $5,000 grant. And that the difference here really is that much of this is intended to fix the deficient housing stock that is affordable for first-time home buyers to purchase. Those are the affordable homes, but often folks will seek to purchase those, and then after a home inspection, they're denied their loan because there's too many deficiencies. And there's no source like this that can come in with a flexible loan like this that has no payments to actually correct all the deficiencies in the home so that they can get their mortgage and purchase it. So this was a big trust, with the governor and our constituents we've talked to, also from Susanna Davis, to get a goal in here to provide much of these grants to the BIPOC community. So that's been added. The rest of the bill, as far as the registry and components on the VHIP rental side, were really small. I would call them, more technical changes that the House sort of worked on. And if you want Sean to maybe dive into some of those, he would probably be better equipped to explain those.
Actually, now my memory's refreshed. I'm not sure. We heard from Representative Stevens. I can't recall whether we ever heard from our counsel, David Hall, on
Yeah.
the changes. We
Do you
did?
remember on Tuesday, he posted the draft 2.1 that had in highlight, I believe, all the changes from our bill, or yes.
David, did you already walk us through all the changes from the House? I can't remember. You did?
I
Okay.
think so, but
You
Yeah,
don't
we
for
did a
sure
little bit.
either. Okay,
I watched it last night. You did.
okay, thank you.
glad for you
I'm
too.
sorry, it's the end of the session.
No,
Hard to keep
and
things- hard for you to-
Mr. Chair, for right now, it is useful actually to go back to Tuesday. Nathan has it posted on our Tuesday page under David's S79. I think it's draft 2.1. And is that right, David? Yeah.
All right,
2.1.
I do
Because that has
remember
the-
this now, yeah,
That
okay,
has the highlight differences between the House version and the Senate version.
right. I do remember that document. Draft 2.1.
Yeah, it's the second one down. It's not the
Right,
3.1.
I
which is
see
the
it
final.
here. Yeah, I want to sort of, what I want to do is I want to dispense with any problems we may have in what changes they made in S79 as we sent it over, and then move on to the whole new section on homeowners repairs and the loan program. So at the risk of being repetitive, could you do that for us again, David Hall? Just, I don't think there were many, but if you could just go through S79 as we sent it over and look and focus on the changes the House made to our version.
Happy to do that. And I do think it can go quick. I can share the screen and just take everybody quickly because they are on this version of 2.1, they are highlighted. And, as the Commissioner indicated, I think a lot of it is just sort of technical housekeeping stuff. There are a couple of places you'll want to, get a check on. I'm going to try to, it's a long document and I apologize for the scrolling. This change again, is everybody with me right now?
We're on the bottom of page 3.
So yes, so David Hall, Legislative Council S79. What you're looking at on your screen, what I'm going through is a draft. Senator Ballant has joined you, I see.
Okay, well, if Senator Ballant has joined us, we'll just very briefly, because we need your vote on H157 as amended, and we've held open the vote for you to vote.
Thank you, Mr. Chair. I vote in the affirmative. Yes.
Thank you, Senator Ballant. Okay. So let's go back to David Hall, I'm sorry.
No worries. So again, the document as Senator Clarkson referenced is draft 2.1. This is the version voted out of House General, but it has highlights in it to show the changes that are different from the Senate version. And maybe it'll be helpful for me to just say, this change is clarifying versus there is some substance.
Okay.
And so for instance, this first change is clarifying, just to be sure we're talking about housing leased or offered for lease and that it corresponds to the defined terms, dwelling unit and short-term rental. Those are defined in other sections of law. There's a slight, it's clarifying, but it does, it changes the scope here. We're talking about DPS authority for inspections and its ability to adopt rules and prioritize how it manages its inspection functions. Right now, because of the way this chapter and subchapter have been originally framed, they were just fire. And over time that is expanded.
Right.
And obviously in this bill it expands to include rental housing, health and safety. So striking the term from fire clarifies that the rulemaking authority, the ability to conduct and prioritize its inspection regime is not just related to fire. It's all things under which it has authority.
Okay.
Line 15, just changing the word from investigation to inspection. That's a technical change that relates to how it was referred to in the local health official code. This is a little bit substantive here, lines 13, 14, and 15. And there, I think there is a question about DPS's capacity, interest in doing this. I explained previously, when you guys voted this bill out, you said if the whole building is affected by a violation, it should post a notice of inspection in a common area of the building. The House changed it so that it requires DPS to give direct notice to each tenant in the building and may post the notice in a common area.
So, okay, if an entire building, so it has to be like a common thing, like
Right.
the heating system for the whole building.
Sure.
So you have to let each individual. So what is the tenant, if we're talking about tenancy here, is the tenant responsible to cure the defect? Or this is just letting them know that there may be a danger or a deficiency in their building?
Yeah, it's the latter. I mean, so the situation would be that the tenant, or probably the tenant, calls and says, I have a problem, and then an inspection is conducted. You know, the law says write up this notice of inspection, and the inspection report has to have, you know, the sort of the details of what's wrong and how to fix it and when. And the thought is, well, what if it is a major structural issue or something that would affect everybody in the building? And the tension is, do we require DPS to track down every individual tenant, or can we post it in the lobby or on the mailbox, et cetera?
And there's no limitation on size of the building here, right?
There is not. So it could be a duplex, it could be an apartment building.
Right.
So, I mean, practically, I understand what they were trying to get at. I actually think the notice in a common area is more important because tenants change over all the time. You're not going to open the mail of another tenant who might have been subleased, whatever. So then you have, I mean, I could tell you, you know, you have a lot of that kind of mail. You're trying to track down the right person who doesn't live there anymore. And instead, the individual tenants don't get the notice who are actually there. So I think this would, yeah.
I think we do need to hear from Mike DeRocha on this if they have a concern. I wonder if there's already a practice on this for other kinds of violations that they're working with. But let's go on.
I see Mr. DeRocha. Did you want to hear from him now?
No, yeah. Well, he'll be next. Let's keep going.
Okay.
I don't want to make this too choppy. Okay.
All right. So I do believe, again, pardon the scrolling. This is just clarifying. It just makes sure that people who are going to be displaced will get a notice. There was a question about and versus or, and
Right.
it's resolved.
That's a clarifying.
So we've moved now to the registry requirements and the data that will be provided. And I think I told you already that this just expands so that it asks for the information about owner, landlord, or property manager to the extent those may be applicable. And then phone number and email, because again, not everybody has email, not everybody. So that's the reason it's structured in two different subdivisions. But the key component there is to not just say owner, but to say also landlord or property manager, if those are applicable.
I understand. I understand the difference between owner and property manager.
Right.
I'm not sure I understand the difference between owner and landlord.
Well, it's because you could have a sublease situation, and you could actually require both. You could have multiple owners, but only one person actually, you know, is sort of the landlord in charge of conducting the leases. I think it's more of the former, though. I think it's a sublease situation where one person owns the building, then there may be a long-term tenant who subleases part of the building or all of the building as well.
And that person becomes the landlord?
Just the way we're referring to it here, I think, yes. It's a lessor, I suppose.
Okay,
The piece in D here, Senator Brock had originally raised concerns about the data on this registry and who could get it and what it could be used for. And it left the Senate with some sort of broader language that it could be disclosed or to promote the public good. The House narrowed this, I would say moderately to significantly, to say not only is the data on the registry exempt from public inspection and copying, so it's not a public record, the department shall not disclose that data except as provided in 2. And 2 says it can only disclose the data to other persons for the purposes of protecting public health and safety. It cannot disclose the data for a commercial purpose, and it shall require, as a condition of receiving data collected pursuant to the section, that the person who receives that data has to take necessary steps to protect the privacy of the data and prevent further disclosure except as permitted here. So I would say this is a fairly significant narrowing of the language. I don't know, where that squares with your intent, but it's a narrower scope.
is there precedent for this paradigm here?
I mean, I can't give you a specific example, but the range of, just public records in the scope of their availability or disclosure is just legion. I mean, there are over 100 different Public Records Act exemptions, and they have all kinds of varying different applications. So I would say that this is just a pure policy choice of, do you want the public to get this or not? Do you want them to be able to disclose it or not? And for what purpose?
So I know there are several purposes of having a registry here, but from a John or Jane Q public perspective, what interest would a consumer have in this information? That's a question for you, David, and also for other committee members, and maybe also for the department. How essential is this to make this widely available?
That's pure policy. I don't have an answer, I'm afraid. That's for other people in the room to
I think let's flag this, Mr. Chair, and ask Sarah, ask the advocates about this
Okay.
when we go back and discuss
So
it.
our basically what you're saying, our language seemed to be broader, but in their narrowing, the House, you're not sure that it's not in compliance with our intent.
Well, because you passed language that said they could disclose this data to promote the public good, and that discussion was held in the House General Committee, and my testimony at the time was that that's a broad term. It does not have a definition. It could be for lots of different purposes. I talked about the police powers, promoting the public good, the concept underlying that, versus a narrower approach, which is to protect public health and safety. So there has to be that's a distinction with the substantive difference. And they chose the latter course because they did not feel comfortable with something as broad as promote the public good, and to leave that in the discretion of the department. They were thinking more along the lines of, I guess, emergency circumstances and protecting public safety or health. So, I mean, that's the only context I'm afraid I can offer. I mean, I think, again, it's just how broadly available should this be, and for what purpose will it be used?
Okay.
Those are questions I can't really answer.
I think Senator Clarkson's suggestion is a good one. We'll ask the witnesses where they see this information being useful to the public. Okay.
Well, I remember when we discussed this last year, an earlier version. One of the issues I think that Senator Clarkson raised was by having this list during Hurricane whatever, we would have been able to contact people to see if there was rental housing available for people who were displaced. I thought that was an overreach because I thought that was none of anybody's business. And to have the state contact people to effectively place them or seek rental, I just didn't think was an appropriate person for this. And that was one of the reasons that I wanted to see this narrowed.
Okay. Let's keep
But
going.
you asked two different questions. I think there is public purpose in terms of education and law changes and a whole host of reasons that have been identified, state, municipal, and regional government entities and nonprofits being able to access this. But you asked a consumer question. What was the point of the consumer having access to this? And I think that's the question that we need to ask Sarah and the other advocates.
Okay.
All right. So in the registration requirements, I think the most significant changes relate to subsection C, which is sort of the deviation from the general rule that you have to register. And when it left the Senate, you already had the treatment of mobile home parks and how that needs to fit neatly into the constructs we have regulating mobile homes. But the House added two other components in the sort of exemption modification realm. The first one being in subdivision 2 here, and that concerns housing that is basically not otherwise available for lease to the general public. And again, the specific circumstances that were contemplated were the, first, renting to family or friends, second, home share, and third, personal care providers. So again, the exemption says basically, if this is offered exclusively, in one of those if this is not offered to the general public, then you don't have to register. If it is either part or full-time available to the general public, then you do. And then the third piece was housing provided as a benefit of farm employment. Again, that is set to sunset in 2 years, but right now that kind of housing would be fully exempt from the registration requirements in this section.
Are we asking for any information back within those 2 years, or are we just going to be sort of in the same situation of knowledge or reports or data, and we're just giving them 2 more years in which to comply?
I don't think there's actually a specific reporting requirement on the subject in the bill. It's the House General Committee's intent to hear it's part of a much bigger conversation they're having about housing standards, availability, quality, enforcement for farm housing, for migrant housing, and they felt like they had not received sufficient testimony to understand the full scope of impacts on farm housing by including them in this bill. So they limited this particular type of farm housing until they had a better understanding.
Sorry, I don't see in the language where we're seeing it in 2 years. I apologize.
Well, it's actually set up as a prospective repeal. So that's what section 3A is.
Oh, so we're going to see that in the time frame at the end?
More or less, yes.
Yeah, okay. So this is exempt for 2 years, farm housing that's related to farm employment. That's a quid pro quo for working on the farm. Right.
It's part of your compensation.
Part of your compensation.
And while it is largely subject to 9 VSA chapter 137 governing landlord-tenant law, there are some important distinctions, in particular in ejectment actions, that differentiate it from other kinds of leases.
Right.
Okay, I'd be interested to hearing a little bit more about.
Yeah, I have concerns
the
about
presumption that this
quality of housing.
That this goes forward as part of this bill. I mean, I guess I'm like the House. I don't know enough about whether it's unique enough kinds of tenancies that, or they have their own protections or lack thereof, or need different protections. And I'm not sure at this point, whether we should have a default position that this
Sure.
goes into effect as opposed to the burden being on us to pass something affirmatively. But we can talk more about that. Okay, let's go on.
I'll just mention that I think the underlying reasoning for this particular, because so bear in mind that that is a defined term. So this would not apply to a farmer who happens to lease a property. It's specifically to the housing that's part of the employment package. And so in a
Right.
sense, that housing is not available to the public. And if it stopped being used as housing provided as a benefit of farm employment, it would just be a lease and it would be subject to registration. So again, it's that narrow sort of construct. On line 18 here, it's basically a 15-day grace period for the late registration fee. Any questions on that?
Nope.
All right. And this is the prospective repeal that I just referenced. Again, they changed the allocation of the money a little bit. So DPS starts with 100 and DHCD starts with 300 versus 2 and 2.
Okay, so I hate to do this to our witnesses, but a few of us have to be on a call now, and we're on the floor at 10. But I'm not going to ask you folks to go through this again tomorrow, but I hope the witnesses can be back again tomorrow. It's a little challenging when we only have an hour and 15 minutes. We're trying to do our best. My apologies, but we do have to adjourn at this point. Sorry to cut you off so abruptly, David. I didn't realize we were at 9:40.
It flies by.
Yeah.
It flies by.
So Mike DeRoche, I am going to ask you about that notice thing tomorrow and posting, and whether you have any comparable situations in your department where you have to post notices to large buildings already, and whether you do it individually, apartment buildings, or whether you do it in common areas. I think that should probably follow, well, it could follow that practice. Anyhow, that's it. My apologies.